There is a letter I have been meaning to write for 2 years. Not to a lawyer, not to a court, not to anyone in the Ashford family, to you, if you are the kind of person who has ever been told that your name was the wrong one to have in a room. I want to tell you what happened when the wrong name turned out to be the only right thing about me. My name is Mara Celine. I kept it when I married Julian Ashford 3 years ago, and that decision, small but personal, made in the 10 seconds between the clerk asking and the line waiting, became the crack through which everything else eventually poured. The Ashford family had opinions about the name from the beginning. Julian's mother, Catherine, expressed hers with the particular grace of a woman who had been raised to consider directness vulgar and implication an art form. She did not say the name was wrong. She said, at our first dinner together, that it was unusual for a wife to maintain a separate surname in their circles, that it created a certain confusion at formal events, that their family's name carried a certain weight in Charleston that she hoped I understood. She said all of this while passing me the bread basket, which was the most efficient delivery system she could have chosen, something that looked like hospitality containing something that was not. Julian's brothers, Thomas, the eldest, who ran the family's development corporation, and Reed, who managed the legal portfolio, were more direct in the way that men who have spent their whole lives in rooms where they set the terms are more direct. Thomas told Julian, within the first month, that the marriage was a liability. He did not mean emotionally. He meant the word the way men like Thomas mean it, as a balance sheet entry, something that reduced a position rather than strengthened it. Reed said nothing about the name directly. He looked at me at family gatherings with the specific quality of attention that legal minds use when they are assessing something they may eventually have to address. I did not know, for the first 2 years of my marriage, why the name specifically bothered them. I assumed it was class. It is easy to assume class when you are the person who grew up without it in rooms designed to remind you of that fact. I was a forensic records archivist, not a title that commands the same weight as the Ashford family's civic philanthropist listing in the Charleston Magazine annual feature. My mother had cleaned other people's houses until her back prevented it, and then she had taken in alterations. And I had gotten where I was through public university scholarships and the specific, stubborn quality of someone who has been told their whole life that their access to certain things is provisional. I was good at my job because I understood documents the way people understand a language they learned not in a classroom but in a house where it was spoken, intuitively, bodily, with an instinct for when something was missing that did not require a checklist to identify. I did not know, yet, that this instinct was the most important thing I possessed in the context of the Ashford family. I did not know, yet, that the name I had kept was not stubbornness. It was inheritance. The night of the Ashford Civic Gala, I was standing near the bar in a dress Catherine had suggested I reconsider and had worn anyway, and I was doing what I had learned to do at Ashford events, which was to make myself pleasant and present and unremarkable, to carry my own weight in a room that had decided it did not want my weight there. My name was in the printed program because I had coordinated the historical records portion of the evening's presentation, the display of the Ashford family's philanthropic history, which I had assembled from county archives with the particular irony of someone who did not know yet that she was assembling the history of a corporation that contained, buried in a sealed file across the city, her own family's name. George Ashford walked through the main entrance at 8:22 and stopped within 30 seconds of picking up the program. He crossed the room toward me with the directness of a man who has learned that time is more finite than he previously believed, which I later understood had to do with 6 months of medical treatment whose nature the family had been vague about. He stopped in front of me and looked at the program and then at me in a way that had nothing of his wife's managed social assessment in it. He said, "Where did you get that name? Let me tell you what time it is where you are. Not because I want to know the geography, because I want you to understand that this is the kind of story that began for me at 8:22 in the evening at a charity gala in Charleston, South Carolina, and ended somewhere I could not have predicted from that starting point, and the distance between those two places is everything I want to tell you about." George asked me to come to his attorney's office the following morning. Alone, not with Julian, not with anyone. He said it with the urgency of someone who has been waiting a long time for something and is afraid that waiting any longer will cost him the chance entirely. I told Julian I had an early errand. I did not tell him where I was going because I did not yet understand what I was going to, and I have learned, in my professional life, that the worst thing you can do with incomplete information is share it before you understand its shape. Francis Holt's office was on a quiet street in the historic district, the kind of office that announces its longevity through the quality of its furniture rather than its technology. Dark wood and full bookshelves and the particular stillness of a room where difficult things have been said many times and the walls have absorbed all of it. Frances herself was in her late 60s, silver-haired, with the measured quality of an attorney who had spent decades working at the intersection of family and money and had long since stopped being surprised by either. George was already there when I arrived. He did not make small talk. He gestured toward the chair across from Frances's desk and said, simply, show her. Frances produced a sealed file from a drawer that had a physical lock on it, not a filing cabinet, a dedicated drawer with a key she wore on a chain. The file had a date written on the outside in black marker, 1987. She set it on the desk and opened it with the care of someone handling something that has been waiting long enough that the handling itself matters. Inside was a founding partnership agreement for Ashford Development Corporation, the entity that had become, over 35 years, the foundation of the family's $40 million real estate portfolio, their civic identity, their position in every room in Charleston that mattered to them. The document was 4 pages, typed on a manual typewriter, with 2 signatures at the bottom of the final page. One was George Ashford's, the other was Daniel Saline. I looked at that name for a long time. Saline is not a common surname. In the 34 years I had carried it, I had met 2 other people with it, a woman in my mother's alterations circle whose husband had emigrated from Greece, and a man at a professional conference whose connection to my family I had never investigated because it had not seemed relevant. I had carried the name the way you carry things that were given to you before you understood their weight, as identity, not as information. I asked Francis who Daniel Saline was. George answered. He said Daniel was his original business partner, the man who had co-founded Ashford Development with him in 1987, who had contributed the initial capital and the land contacts and the specific knowledge of Charleston's development landscape that George, who came from old family money but not from real estate experience, had needed to make the corporation viable in its first decade. He said Daniel had been the operational intelligence behind the corporation's first 7 acquisitions. He said that without Daniel, there would have been no Ashford Development Corporation, and therefore no philanthropic legacy, and therefore no gala, and therefore no program with a name on it that had stopped him mid-step across a room 35 years after he last saw the man who carried it. I asked where Daniel was now. George said, that is the question I have been trying to answer for 15 years. He was not searching for me. He was searching for my father, a man who disappeared in 2009 and whose daughter had walked into his family without either of them understanding why that name kept finding its way into the same rooms as the Ashford name. Francis explained the succession clause while I was still processing this. The 1987 partnership agreement contained a provision, standard in partnerships drafted in that era, she said, though rarely maintained across this length of time without modification, specifying that if either partner died or became permanently incapacitated without a formal buyout having been executed, the deceased or incapacitated partner's equity share passed directly to their lineal descendants by surname. The clause identified succession by surname specifically because the attorney who drafted it in 1987 had been working from a model agreement common in that period, which used surname identification as a proxy for family line in the absence of more sophisticated estate planning language. Daniel Saline had disappeared in 2009. No formal buyout had ever been executed. The partnership agreement had never been formally dissolved because dissolving it would have required both partners' consent or a court order, and obtaining a court order would have required acknowledging the agreement's existence in a public proceeding. I asked Frances what the equity split had been. She turned to the relevant page of the 1987 document and indicated a figure. Daniel Saline had held a 40% founding interest in Ashford Development Corporation. I sat with that for a moment. 40% of a corporation currently valued at $40 million. I did not perform a calculation out loud. I did not need to. Frances's expression told me she had performed it many times. The family's embarrassment campaign suddenly had a financial architecture underneath it. Thomas and Reed had been managing me out of rooms where my name might be recognized, out of conversations where someone might connect the surname to the founding document, for 2 years, possibly from before the wedding. From the moment Julian mentioned the woman he intended to marry and her name landed in a room where 2 men who knew the 1987 agreement existed immediately understood what it meant. I looked at George. Does Thomas know about this document? George was quiet for a moment that told me everything before he answered. I believe Thomas has known since he took over the corporation's operational management, he said. Approximately 14 years ago. And he never dissolved the partnership legally. Dissolving it legally would have required acknowledging Daniel's position, Francis said, which would have raised questions about why a 40% founding partner had never received a buyout, and where that partner was. I drove home from Francis Holt's office through the historic district, past the squares I had walked through for 2 years as a person who had been told she did not quite belong in the city's oldest rooms. I thought about the document in that sealed file. I thought about the name on it. I thought about the fact that the Ashford family had spent 2 years engineering my discomfort in every room they controlled, and I had spent 2 years assuming they were embarrassed by my class. They were not embarrassed by my class. They were managing a 40-year-old liability that happened to be walking around Charleston with its name attached to it, married to the one member of the family least likely to be told why the name mattered. When I got home, Julian was in the kitchen making coffee. He turned when I came in and read something in my face that made him set the coffee down. "Tell me," he said. So I did. Julian listened the way he always listened to things that mattered, without interrupting, without reaching for an explanation before I had finished building the picture, without the particular impulse some people have to resolve tension before they have fully understood what is causing it. When I finished, he was quiet for a long moment. Then he said, "Thomas knew before the wedding." Not a question. A conclusion arrived at through the same logic I had been working through on the drive home. Julian had known his brother for 44 years. He understood the specific quality of Thomas's silences, and he was now retroactively applying that understanding to every silence Thomas had produced in the 2 years since Julian had first mentioned my name. He called Thomas that afternoon. I was in the next room and I did not try to hear the conversation because some confrontations belong entirely to the people having them, and this one was between brothers in a way that predated me and would outlast whatever happened next. What I heard was the quality of the silence after Julian hung up. It was the silence of a man who had just received confirmation of something he had hoped was wrong. He came into the room where I was sitting and said, "He knew. He's known since he took over operational management." He called it a legacy document issue that had been managed. Julian sat down across from me. He used the word managed. That word contained everything. A 40% founding partner's unextinguished equity claim is not a legacy document issue. It is a structural legal fact that does not become manageable through time or inattention. Thomas had been calling it managed for 14 years, which meant he had been calling it managed in conversations with Reed and their attorneys and possibly their accountants. And the management strategy had included, at its social layer, ensuring that no one named Celine ever sat comfortably enough in an Ashford room to start asking questions about why the name felt familiar. I went to work the following morning, and I did what I do when I need to understand something that exists in documents rather than in conversations. I pulled the public incorporation records for Ashford Development Corporation from the South Carolina Secretary of State's archive, records that are public, accessible, part of the permanent filing infrastructure that my professional life had trained me to navigate the way other people navigate roadmaps. I pulled the county property records from every major acquisition the corporation had made between 1987 and 2009. And I pulled the probate filings from Charleston County for the years following Daniel Celine's disappearance. The probate records were where I found the thing that changed the shape of everything I thought I had understood from Francis Holt's office. A presumptive death certificate for Daniel Celine had been filed in 2010, 1 year after his disappearance, which was the minimum waiting period under South Carolina law for a presumptive death filing when a missing person had left no confirmed evidence of life. The filing was standard in its form, specific in its details, and unremarkable in every respect except one. The petitioner who had filed it was not a family member. It was not a government agency. It was an attorney. The attorney's name on the filing was Francis Holt. The same Francis Holt who had produced the 1987 partnership document from a locked drawer and told me George had been searching for Daniel's daughter for 15 years. The same Francis Holt who had been, by her own account, trying to help George find the heir to a claim she had simultaneously filed a document to legally extinguish. I sat with that for a long time. In my professional experience, A document that does two contradictory things at once is not a mistake. It is a choice. The question is always whose choice it was and what they believed they were managing when they made it. I went back to Frances Holt the following afternoon and put the probate filing on her desk the same way George had once put a sealed file on it in front of me. She looked at it. She looked at me. The quality of her composure in that moment was the composure of a person who has been waiting for this specific meeting and has had years to prepare for it. She told me the truth, not the version she had prepared, the actual truth, because the filing on her desk had removed the version she had prepared. George had not filed the death certificate to erase Daniel. He had asked Frances to file it because he had received, in 2010, a letter that he believed came from Daniel, handwritten, delivered through a mutual contact, saying that Daniel had gone into hiding after discovering that Thomas had been diverting corporation funds through operational accounts that Daniel's equity position would have entitled him to audit. The letter said Daniel was afraid. It said that if anything happened to him, his daughter should be told to find Frances Holt. It said to file the death certificate because it would close Daniel's public record and protect his daughter from whatever was following him. George had done what the letter asked. He had filed the certificate and retained the partnership document and begun, quietly, trying to find Clara Celine's daughter. What he had not known, for 15 years, was whether the letter had actually come from Daniel, or whether his sons had written it, knowing that a presumptive death certificate would legally simplify the question of the unextinguished equity claim in ways that a living partner's continued existence could not. I drove home from that second meeting with Frances Holt and I called my mother. Clara answered on the first ring and said, "Before I could begin, I've been waiting for this call for 15 years. She told me everything. Daniel had not abandoned us. He had gone into hiding, real hiding, planned and deliberate, after receiving a threat specific enough about my safety that he had made the decision to remove himself entirely rather than draw whatever was following him toward a woman and a 4-year-old child. He had contacted my mother once, through a trusted mutual friend, approximately 2 years after he vanished. He had told her one thing above everything else: keep Mara's name as Celine. He had told her the name would matter eventually. He had told her not to look for him. My mother had spent 30 years protecting me with a silence that was also a secret and also a decision that she had made alone and had never stopped second-guessing. She was crying by the time she finished telling me. Not in the way that people cry when they want comfort, but in the way that people cry when they have been holding something for so long that the release of it produces something that is not quite relief because too much time has passed for relief to be the right word for it. I did not cry on the phone. I held what she had told me in the careful, methodical way I hold documents that require processing before they can be filed, understanding their full weight before deciding where they belong. My father had not left me. He had left to keep me from being reached by something that had already frightened him enough to give up everything else. The name he had told my mother to keep was not stubbornness. It was the last thing he could do for me from a distance. It was a thread he left running from 1991 to the room where I would eventually stand, 30 years later, holding a program at a charity gala, with a man across the room who had been looking for it. 3 days later, my phone rang at 6:14 in the morning. The number was unfamiliar. I almost ignored it. Then I answered. For several seconds, no one spoke. I heard breathing. Then a man's voice, older than I expected, quieter than I imagined. Mara? I closed my eyes, because I already knew. You kept the name. I couldn't answer. 30 years of questions collapsed into 5 words. Finally I whispered, Dad? His breathing caught. I wasn't sure I'd ever get to hear you say that. Daniel Celine was alive. Not in another country. Not living comfortably under another identity. He had spent the last 17 years moving from place to place under witness protection arranged through federal investigators after agreeing to cooperate in a financial fraud investigation involving several Charleston developers. Thomas Ashford had never acted alone. The missing corporation funds Daniel discovered in 2009 were part of a much larger network of fraudulent land transactions. When Daniel confronted Thomas privately, Thomas warned him that powerful people would rather eliminate a partner than expose decades of illegal profits. Daniel believed him. George hadn't. Not then. By the time George realized how serious it was, Daniel had already disappeared. The letter, the death certificate, the silence. Every terrible decision had been made by people trying to protect someone else. Some succeeded, some failed. Daniel told me something that stayed with me forever. I never wanted you to inherit money. I wanted you to inherit the truth. The next surprise came from George. Without telling Thomas or Reed, George had quietly hired private investigators years earlier. every invoice, every surveillance report, every failed lead, every payment. He kept everything. Thousands of pages. 14 years. He had never stopped looking. Not because of the corporation, because he believed Daniel deserved better than disappearing without anyone trying. When George handed me those files, he simply said, I should have believed him sooner. Meanwhile, Thomas believed everything was still under control. He had no idea Daniel was alive. He had no idea George had preserved decades of evidence. Most importantly, he had no idea George had scheduled another Ashford Foundation gala. The same ballroom, the same donors, the same business leaders, the same reporters. Everyone Thomas cared about impressing. He assumed it was another fundraising event. It wasn't. Halfway through the evening, George walked onto the stage. The room quieted. He thanked the guests. Then he said, tonight is not about celebrating the Ashford legacy. It's about correcting it. Large screens behind him lit up. The first image appeared. Ashford Development Corporation. Founding Partnership Agreement. George Ashford. Daniel Saline. 40% ownership. The room became completely silent. Then came bank transfers, corporate records, internal memos, accounting summaries, investigator reports, documents Thomas had assumed would never leave locked cabinets. George didn't accuse anyone. He simply displayed facts. Facts have a way of sounding louder than anger. Thomas stood. He demanded the presentation stop. George ignored him. Then George looked toward the ballroom entrance. I've spent 15 years looking for my partner. I'd like everyone to meet him. Every head turned. Daniel walked inside. Older, thinner, gray-haired, alive. Thomas looked as though every calculation he'd ever made had collapsed at once. For the first time since I'd known him, he had nothing to say. Investigators waiting outside entered minutes later. Apparently George had coordinated everything with state authorities weeks before. Thomas wasn't arrested that night for hurting my feelings. He wasn't arrested because of family drama. He was arrested because documents don't forget. Records don't become less true because they're hidden. Years of financial misconduct finally caught up with him. Reed resigned from every corporate position before sunrise. Months later, the settlement became official. Daniel's ownership interest was restored. George transferred his own remaining shares into a charitable trust jointly managed by Daniel and me. Not because I wanted control, because George said the company should finally belong to people willing to tell the truth. We renamed the Historical Scholarship Program after Daniel Saline. His name finally appeared exactly where it always should have. Not hidden, not erased. Remembered. Sometimes people ask whether I regret keeping my maiden name. I always smile, because the answer was never about tradition, or marriage, or pride. A surname is only a word, until someone spends 30 years trying to erase it. Then you realize, names carry history. Names carry promises. Sometimes, they carry justice. If you've ever been made to feel like your family history wasn't worth remembering, I hope this story reminds you of something. Truth can disappear for years. It can be buried inside boxes, locked inside filing cabinets, hidden behind expensive lawyers. But truth has remarkable patience. Eventually, someone opens the right file. If this story stayed with you, I'd love to hear your thoughts. Have you ever discovered that a small family secret turned out to change everything? Share your experience in the comments. If you enjoy slow-burn family drama, betrayal, and stories where quiet truth wins in the end, subscribe to Betrayal Chronicles so you don't miss the next story. This story is a work of fiction created for entertainment purposes. Any resemblance to real people, organizations, businesses, or events is entirely coincidental. The situations, characters, and dialogue are fictional and are intended solely as dramatic storytelling.